Hi, I'm Brian with Hanning Law Limited, attorney for businesses and creatives. Today I'm back with the next video in my series on trademark laws, and we're going to be looking at office actions. So, an office action, as the definition, is a communication from the examining attorney to the applicant of a trademark, indicating that there is some kind of issue with the application itself. Now, there are generally two types of office actions, and that means the spectrum of how bad an office action is very broad. And so it can literally be something resolved in 2 days, or it can be something that takes months and months to deal with. Let's look at that first situation of the short, very minor, but still problematic office actions. These are technical office actions. They are issues where, for example, for Hanning law, I might need to disclaim the word law. It is a industry term that is used by practically every law firm, not all of them, but almost all of them. And it can be something where we don't want to give one person that word. And so we have to disclaim it. We have to say, other than this particular circumstance, I don't own or can't control the word law. Frequently, you may just get a phone call or an email that says, hey, can I fix the application by doing X? You say yes, they do it, it moves on in the process. Other times they will do it as a more formal, non-final office action. It'll go into the system as a non-final office action. You'll get notified of that, and you'll be asked to fix these items. These are things where you're going to more or less accept suggested changes or make slight modifications that you can easily do, and you're going to be moving through the process. The other situation is a substantive office action. A substantive office action is the phrase, we can't register your trademark because of this other trademark or this significant issue. Typically, that's going to be in the form of a 2D refusal. Sometimes it's failure to function. Failure to function is not 2D, but it is the idea that the thing that you filed is acting as just a picture, or it is words that are so common that they're just not indicative of source. But the more common ones are your Section 2 offenses, 2B through 2E generally. The most common is your likelihood of confusion, 2D. 2E is descriptive, as in, I looked at a dictionary, it says that law is the phrase that lawyers use to practice law, and that's all of your trademark, you can't register it. When you get a substantive office action, you have the opportunity to make your case that a customer wouldn't be confused, that your failure to function is an incorrect reading of the situation and that it does point to you specifically, or that it's not descriptive. There's this hidden double entendre, this other meaning that makes it connective and registerable. So you typically are going to have 6 months to respond. You'll want to respond in full, and you typically have multiple chances to get it right. Though the more you get it right in the first time, the less of a duration you're going to have to be talking about. We'll run out of chances with the examiner. And if you still want to pursue registration, you can take the registration and take it to the Trademark Trial and Appeal Board. And at that point, you're basically taking it to another source to argue that the examiner got it wrong. That can be a high bar to overcome, but it has been overcome before and it will be again. But just know that the more you're arguing, the higher the cost. And when you're making these arguments, if you're not winning with the examiner, you may have a conversation that needs to occur about if you want to continue making these arguments. The other element with that is frequently in a substantive office action, they may suggest that you switch to a register from the principal register, which is what everybody tries to get on in the first place, to the supplemental. This is going to happen very frequently with descriptiveness. And what you're basically doing at the supplemental register is you are getting many of the benefits, not all and not necessarily the ones you're looking for, but a number of the benefits of a registered trademark, including the R in a circle, and an opportunity to build a record to prove that your name either doesn't create confusion, has a secondary meaning, has these other arguments that you need to create to try in the future to move it back to or onto the principal register. That can be a very useful tool depending on the circumstances. With all of that, we're going to go to the next step. I'll talk to you all next time.